Here are 3 important deposition tips, mostly for injury and employment and wrongful termination cases that your attorney might not have shared with you. Number 1, do not exaggerate when you testify. Do not exaggerate about your injuries. Do not exaggerate your emotional distress. Do not exaggerate how bad the other side is. Let me give you some examples. It's perfectly fine to testify that your right shoulder was injured in an accident, but your left shoulder wasn't injured and it doesn't hurt. It's perfectly fine to testify that you've had neck pain for the last 6 months since your accident, but you didn't have that much back pain. The problem is when you say that every single part of your body hurts, every single part of your body was injured in the car accident. It's very hard to believe, and in the vast majority of cases, this simply cannot be true. And once you testify this way, this gives the other side an ammunition against you to argue that you're exaggerating, you're making things up, and if you're exaggerating about this, you're probably exaggerating about many other things. The same is true about employment and wrongful termination cases. If you claim that you've been discriminated based on every single classification because of your age, disability, race, religion, gender, sexual orientation, it's really hard to believe. If the deposing attorney asks you, do you believe that you've been discriminated based on age or race or disability, you should not be answering yes to every single thing just because they're asking you that. It doesn't make your case stronger, it makes your case weaker. If your case is about age or about disability or about race, or let's say about 2 out of all of those things, then talk about the things that you can prove. Do not push arguments, do not push theories that you simply cannot prove, because it's going to weaken your case and it's going to make you look dishonest, and it can really hurt your case, especially if your case goes to trial, because judges and juries don't like giving awards to people who they cannot fully trust. The same applies to some other aspects of your deposition that might come up. Let's say that the attorney asks you about how you got along with your supervisor and what you think of your supervisor. It's perfectly fine to give that supervisor credit for their positive qualities. It's perfectly fine to testify, we've got along great, we worked together on all these projects, everything was fine, and then one day I complained about, I don't know, sexual harassment, racial harassment, some safety violation, and ever since I complained, he started treating me badly, he started yelling at me, he started giving me the type of tasks that he never gave me before, and everything changed. Maybe he demoted me, he started paying me less, and so forth. You don't have to depict your employer, your boss, as an evil Satan who is evil in everything they do 24/7. That's not what your case is about, and if you do that, it's going to be really hard for the judge, the jury to believe that this is true, because most people know that no employer is really evil all the time in everything they do. And remember, the judge, the jury, they weren't there. They don't know what your employer did to you. All they see is what you're saying and what the other side is saying. And you can bet that your employer is going to be very polished and they're going to present themselves very nicely. So don't make them sound worse than they really are. The same applies to car accidents. If you weren't involved in a rollover accident or a head-on collision with catastrophic injuries, there's no reason to make your injury sound like it was. And number 3, do not act nervous or fidgety. When you act nervous in a deposition in any civil case, when you look very uncomfortable, when you look like some kind of guilty defendant in a criminal case, this will inevitably create an impression that you're lying, you have something to hide. Otherwise, why are you so uncomfortable? Why do you act like you're doing something wrong if all you're doing is you're telling your honest story and you're just talking about facts the way they happened? Now, I know it's easier said than done. Even if you understand that you shouldn't be nervous, you might still be nervous. So one of the best things to do to reduce your nervousness, as they say, practice makes things perfect, is to rehearse. Ask your attorney to have a short deposition session with you, short but intense, where that lawyer is going to be asking you questions, pretending that he's the opposing lawyer, he's the lawyer for the opposing side, where he will be asking you the most difficult questions, questions that you're most concerned about, questions that will make you feel most uncomfortable in the most dramatic and the most forceful way. Once you survive that, once you review how you did, hopefully you can record that session, and then you can look at it together and talk about your demeanor and your answers. Once you do that, chances are that you will be much less nervous during the real deposition, because you know exactly what to expect, and chances are that the actual deposing attorney is not going to be as confrontational and as dramatic as your attorney tried to be during the training session. Of course, watching samples of other depositions in other cases and even reading transcripts of other similar cases as yours can also be helpful, because the main reason that you're nervous is because you don't know what to expect. Once you know what to expect, once you see that the questions for the most part are the same in most depositions, then it will take the elements of surprise out of the whole thing, and then you will have so fewer reasons to be nervous. Thank you.